The class action claim against AstraZeneca Covid-19 vaccine is groundbreaking, and if successful could lead to more claims in the UK and around the world. Let me explain the background to the claim before exploring the factual and legal basis for the claim and what I think will be the defining issues in the court case. The background, and let me take you back to 2020. As the reports of the rapid spread of coronavirus, on the 30th of January 2020, the World Health Organization declared a public health emergency of international concern. On the 3rd of March 2020, the UK government announced its 4-stage strategy in response to the COVID-19 emergency, one of which was research, better understand the virus and the actions that will lessen its effect on the UK population, innovate responses, including diagnostics, drugs and vaccines. On the 23rd of March 2020, the PM announced the first UK-wide lockdown, which came into effect at 1 PM on the 26th of March 2020. The Health Protection Coronavirus Restrictions England Regulations 2020, the first of many COVID-19 regulations issued by the then Secretary of State, Matt Hancock, in England, with the other 3 home nations following suit with their laws. From January 2020 throughout the year, the University of Oxford were quick to begin and develop a vaccine against the new virus as soon as they received reports of a new respiratory disease in China. After starting work on the vaccine in January 2020, our team worked around the clock at an incredible pace. As the UK and its 4 home nations dealt with its reported COVID-19 increased infection rates, hospitalisations and deaths through a mixture of guidance and nationwide and later regional laws, including stay-at-home orders and business closures, the team at the University of Oxford tested a lab version of the vaccine in mice and later through clinical trials with human volunteers. On the 30th of April 2020, it was reported AstraZeneca and Oxford University announced landmark agreement for COVID-19 vaccine, a collaboration to enable global development, manufacturing and distribution of the vaccine. A breakthrough in vaccines began to be reported in late 2020, and on the 2nd of December 2020, the Medicines and Healthcare Products Regulatory Agency MHRA granted a temporary authorization for the first COVID-19 vaccine in the UK, the Pfizer-BioNTech vaccine. On the 29th of December 2020, the MHRA granted a temporary authorization to a second COVID-19 vaccine, the AstraZeneca vaccine, also known as Vaxzevria. Hailed as a British breakthrough, the first patient to take the AstraZeneca vaccine was in the first week of January 2021, a member of one of the top 4 priority groups at the time. And throughout 2021 and 2022, various groups were prioritised and actively encouraged by the government to take those vaccines which were now approved for use. Now to the present case. The British Medical Journal reports dozens of patients and families are launching legal action against AstraZeneca over a rare side effect of its COVID-19 vaccine. The factual basis of the claim, as set out by one of the legal teams involved, Housefield, who are acting for 41 individuals and families who have suffered devastating injuries or bereavement as a result of a rare complication of the AstraZeneca vaccine, includes 13 bereaved families and 28 survivors, all of whom suffered serious injuries caused by vaccine-induced VITT. The legal basis of the claim against AstraZeneca vaccine is under the Consumer Protection Act 1987, and in short, these individuals and families claim the vaccine was defective in that it was not as safe as individuals were entitled to expect. Section 2 of this Act states, where any damage is caused wholly or partly by a defect in a product, in this case the vaccine, every person to whom subsection 2 below applies shall be liable for the damage. So who is potentially liable for damage caused to those individuals and families by a possible successful vaccine claim? Subsection 2 of the Act answers this question and states this. It includes A, the producer of the product, or B, any person who by putting his name on the product or using a trademark or other distinguishing mark in relation to the product has held himself out to be the producer of the product. In this case, the claim is being made against AstraZeneca as the manufacturer and producer of the vaccine. And defect is defined in the Act in subsection 3 as there is a defect in a product for the purposes of this part if the safety of the product is not such as persons generally are entitled to expect. And for those purposes, safety in relation to a product shall include safety with respect to products comprised in that product and safety in the context of risk of damage to property, as well as the context of risk of death or personal injury. Now, AstraZeneca could argue possible defences as set out in subsection 4 of the Act. These include D, that the defect did not exist in the product, that is AstraZeneca's COVID-19 vaccine, at the relevant time, and E, that the state of scientific and technical knowledge at the relevant time was not such that a producer of products of the same description as the product in question might be expected to have discovered the defect if it had existed in his products while they were under his control. There are other defences AstraZeneca could argue too. And not surprisingly, AstraZeneca spokesperson is reported to have said they could not comment on ongoing legal matters, but added, patient safety is our highest priority and regulatory authorities have clear and stringent standards to ensure the safe use of all medicines, including vaccines. Our sympathy goes to anyone who has reported health problems. One interesting possible option for AstraZeneca or the claimants, however remote this might seem, is for either of these parties to bring into the claim the University of Oxford and parties they are associated with and pursue a claim against them. This is because one of the central issues in the claim against AstraZeneca is likely to concern those early vaccine trials, the data obtained from them and any defects known before it was authorised and approved. And questions at court may turn on, did a defect exist in the Oxford AstraZeneca vaccine which made it unsafe? And if so, from the science, was it reasonable for the defect to have been discovered? Or was any defect isolated to a particular batch? Or was there no defect at all? And as these trials involved the University of Oxford team who possessed world-class expertise in vaccinology, they would be well positioned to answer these and potentially other questions. So while the University of Oxford are not mentioned as a party to the claim, they may well be in the future, or at the very least be the principal witnesses to be examined and cross-examined over the data collected and analysed for safety at any court trial if the claim is not settled before then. Feel free to comment, follow, like and share.